All right. Good morning, everybody. Thank you for signing in. And as always, sticking your name, first name, last name, and your property name. That is very helpful. If you are in on the phone, you can mute yourself with *69. I have muted other computers so we don't have background noise as per always. We are going to look at kind of probably not a fun topic, but certainly something that affects us every day. I will also be monitoring the chat box to see if I just have got a couple of people that have entered information here. And for some reason, I am still hearing. Okay, so Victoria, you're on the web. There you go. Now I muted you. Apparently I can't talk. All right. Chat box. If you've got any questions about what we're talking about, please do chat them in. I will kind of monitor the chat box so that we can see. All right, so let me turn on the screen. Thank you, Teresa, for telling me you can't see the screen. That's because I haven't clicked the button yet. Okay. So this is a run through some of the laws that were recently passed. Some of these are just newly in effect. The majority of them become effective September 1. So critically important that you know what these are, because they do affect a lot of things that you do every single day. So we'll talk about that. That's the real value here today. I keep hearing background noise, and I'm trying to get. All right, so a two-part article that was written in the Houston Apartment Association Abode magazine by Howard Bookstaff. He is his job of keeping everybody up to date on items going on. Oops, I'm sorry. So here's where we're going to look. Otherwise, we'll go through each one of these relatively quickly. Water allocation. We're going to talk about the right to summon police. That seems like an odd kind of a new rule, but the point of the matter is that there's been some abuse of that, and then residents get in trouble for that, and so that's why this law was passed. The third one might be of interest. Entry by a former or co-resident to retrieve personal property. So we'll talk a little bit about that because that's been expanded. Hang on, I am trying to get all of the mute. Okay. As people join, I'm sorry, I have to mute again every time people join late. Evictions, we're going to talk about that again. Disability suits, this is going to be really a good one for you. And then towing vehicles and credit cards. So one by one, we're going to look at each one of these. The big thing here for those of you that do water allocation or submetering, they just simply changed the jurisdictional authority. So the Texas Public Utility Commission has got supervision over that. This was effective June 1. The big thing here is that this identifies the Texas Public Utility Commission as who's going to be handling any kind of complaints from residents who feel like they've been overcharged. The rules here have not changed, but the red print at the bottom of the screen is important. If you are doing water allocation or submetering, it is very important that Alpha Barnes is not identified as an owner in the lease. They need to be identified as managing agent or not identified as at all with just the owner involved. I think we do most of our leases with our property names. So for most of this isn't going to be impactful, but just do a double check on that. And we're going to ask supervisors to do the same thing as well. So that's really all it is on water submetering. Hang on, I'm just checking the chat box. Okay. So the next one that we want to talk about is this one, the resident's right to summon police police in the event that they have assistance. Now that's not changed, duh. Residents have always had the right. An owner, like you and I, we can't prohibit or limit this right. So look at the second bullet. The law protected a resident, for instance, in response to family violence, from not being found in default, or creating a problem or whatever. So now it's broader, so they can call the police, or emergency resident believes that an individual is in the need of such services. So it is their right to evaluate the situation and go, I got to call the police. So we can't prohibit or limit this right. I'm sure that we don't in our TAA lease. And notice the next bullet. We can impose a monetary or other penalties for calling the police. Are there people who live at your property who call the police all the time? Yep. But we're the landlord. That's the police's issue. It's not a lease default. If you do have to write the resident up or show them in default of their lease at any time after that call, be absolutely clear that you're making the distinction between the and not, you're not associating. You don't obviously put that in the notice, but you're not associating that right to summon the police. You're kind of watching them really closely, and so you end up looking retaliatory, and that's not going to do well for us. Now it simply grows that any time that a resident in their good opinion feels that. All right, hang on, the chat box is open. Okay, we're good. All right, let's go to the next one. Let's look at this one. So next week, the red print is probably pretty important. Basically, this expands the role, so it gives that person a right to re-enter their own residence or a former residence because someone is, Leanne, I need a last name, or to retrieve personal property because the current occupant is denying entry. Now, this is largely, Taylor doesn't tell me Taylor who. That could be somebody's first name. I'm sorry, just give me the benefit of the doubt there. So this is largely going to be the case with roommates, or somebody moves out and they forgot to get something, or somebody still has something that's theirs. You don't want to be the person who, you don't care about ownership of what's left in it, but the person does have a right to enter. However, second bullet, they have to have a writ. It's not just, I need to go into it because I left something there. My roommate and I are angry at each other, so they're not going to let me in. The point is this person's going to have to go before a JP and issue a writ if the access has been denied. Okay? This writ can be issued even if the resident has not denied access in concern for family violence. That's a big differential. Somebody who, there's no issue of family violence, but because they parted ways on such bad terms, boyfriend, girlfriend, or whatever, this person cannot get back in to collect their stuff. If they went to a judge and got a writ, they would have to be allowed in. Now, obviously, exercising a writ is something that's not fun. If you have to get an officer to help you do that. We are immune from letting someone in under the auspices of a writ. If you follow that last bullet there, the attorney wanted to make very clear about that. If you follow the writ that's been issued by the judge, you and Alpha Barnes and the property cannot be held civilly or criminally liable for any act or omission that arises in that entry. You're basically in the apartment under court order. So this can get nerve-wracking. I would, if it were me and it was my property, I would probably want to do this at least with a witness, if not my courtesy officer, because these things, as you all know, you guys are all experienced managers on this call. This can get violent in a nanosecond. Somebody says something and it can get out of hand. So the bottom line here is that a former or co-resident does have a right to go back into the apartment to get personal property. Now, hopefully they can do that with the person's permission and they agree it belongs to person A or person B. But if not, then we, effective September 1, we have to allow a person with a writ to go in and do that. All right. You know your residents best, but don't be presumptive. If you think at all that there might be an issue here, ask the person to get a writ. And tell them it's for their own protection as well. All right, let's go to the next one. Our friend, Mr. Eviction. Like we needed another eviction rule, right? Kind of crazy. So couple of important tips here. We've just got this on 2 screens. I hope you were able to print off some of the screens. If not, make your notes and then add those notes to them. Just 2 screens here. So this is all about the perspective of appeal, okay? This is not the original eviction proceedings. This is all about the appeal function. The resident wins, we appeal it because we think that they shouldn't be winning. So this, again, effective September 1. So next week, if we appeal an eviction suit for non-payment of rent, okay, non-payment of rent, we can be represented by you and may not need an attorney. Okay, so we now have a choice to present the case, the appeal case, in the county court without having an attorney. Okay, you're used to going to the JP court to file an eviction and get it on the JP's court. County court is different. Here's the deal. If you take that appeal to county court, which is where you would take it, if you go in there, that says if the manager goes and loses, you lose your appeal. Here's the bad part. You may also lose your ability to refile an eviction or even collect past due rent. So while it's great to be able to go and appeal without an attorney, think carefully about this. There's a legal term called res judica, a thing adjudged. So follow the little cartoon here. If you win a civil suit, you can't raise any more claims related to those in the lawsuit if there's already been litigation where these issues could have or were raised. So you would raise the non-payment of rent in the original issue. The parties in the new if the parties in the new one are identical or in privacy with the original parties, then you can't raise the issues again. So that's a legal, a Latin term actually, that means once a suit is judged final, okay, so final in the JP court, all matters were litigated or that could have been litigated in that suit. So when you go to appeal, you're appealing the lower judge's opinion. You're saying, no, this is not fair. Here's my backup. Here's the records of non-payment of rent. We want to appeal the finding of the lower court and plead in the county court that you reverse the ruling and judge in our favor. So if the judge says yes, goody goody, you win. If the judge says no, then all matters litigated in that suit cannot be raised for a second time. So you therefore lose the appeal on the eviction and you lose that non-payment of rent collection. You cannot, you're basically signing off on that rent, because even if 6 months from now you file again on eviction, you can't sue for the balance that was created by that unpaid rent. Okay, so say that you file for eviction, they owe you 3 months of rent, that you lose in JP court, you go to county court, you plead your case, the judge rules against you, you just lost that 3 months of rent. So on posting on our records, you can show them as delinquent and just keep carrying that 3 month balance or try to collect it. But if you go to file eviction from them 6 months from now with another 3 months of unpaid rent, you can't get 6 months of unpaid rent. Does that help distinguish the difference? You lose the ability to collect. Now, so Howard gives an example like this. He says, if an owner seeks recovery for 3 months of rent and possession in an appeal, but the notice to vacate was not delivered properly, okay, the county judge could rule against you for giving faulty notice, and not only do you lose your appeal, but you'll lose the rent. So it's kind of a good news, bad news thing. Yeah, you could sue. Oh, you can absolutely still file with JP. This is on appeal, eviction appeal. So if the ruling in the JP court doesn't go to your satisfaction, the question is, can I file an appeal? The answer is yes. You can file an appeal in the JP court, but you can also file an appeal in county court, and not have to have a lawyer. You're going to have a lawyer on appeal in a JP court. So it just gives you that option. If you've never gone to county court, or you're not going to go to county court, fine, then just ignore this. It is on appeal of eviction suits. All right, the next one is something that was going on. Maybe you weren't even aware of this. Maybe you heard about it, but it never happened to you. Here's what was happening. There were shoppers, testers, who were driving by apartment properties, not even getting out of the car, and just looking for flagrant accessibility violations, like no way, only steps to get up to the office building, or no an insufficient handicap parking space. So this would be in public areas. So what they did was they would just literally drive by and then file a suit against you, the property, because your office was inaccessible. Now remember, accessibility in your office has to do with the ADA, not fair housing. This is Americans with Disabilities Act, not fair housing. Even though your office is a resident spot, they were driving by Chili's, they were driving by Bank of America, they were driving by any public commercial building, and basically not even getting out of the car, seeing what they thought to be an inaccessibility and filing a suit against you in state court. So unfair. So what happened was, and this is effective September 1, they passed a bill reducing by requiring a pre-suit notice and an opportunity to cure. Very important. So this is good news, because if somebody's doing a drive-by at your place and they see an entry that looks inaccessible, or a door not wide enough, then instead of just filing suit, they're going to file a motion, and you'll give a pre-suit notice and a chance to fix it. So this is it's a small thing, but it's a good thing for us. All right, towing. Here's another one of our favorite things that we do, right? Okay, this was actually effective June 15th. So you may already be doing this, but for those of you that may not even be aware, the legislation just recently passed modifies that a vehicle can be towed in a non-consent tow. All right, the law that stood had the 3 little mini bullets in there. The owner, you, agree to take the vehicle to a location of your choosing. The vehicle is towed under the Texas Commission of Licensing and Regulation, or under a statute pertaining to special events. The Texas Commission of Licensing and Regulation has to now allow you to tow it to elsewhere on the property. It used to be it had to go to a storage facility. Okay, many of you have had that experience. It's not a fun experience. Even if someone, it's totally their fault for screwing up and either not parking where they were supposed to or not moving the vehicle when they were supposed to, you tow it and they get mad at you. So now the new rule, June 15th, is you have an opportunity to tow it elsewhere on the property. So let's talk about elsewhere on the property. So if you're going to do that, Howard mentions 4 things that you really need to think about. Where you would put them, how you will identify, as I'm trusting that every one of you as managers are constantly walking your lots as you're out and about on the property, looking at buildings and safety issues and residents and following up on your maintenance teams. You're also walking your parking lots. So you're going to have some kind of system for identifying which of those vehicles have been towed. So you also are going to have to set up rules about how and when the owner can get it. And then remember that you're going to have liability if something happens on the lot where you put them in a different spot and a tree falls on it. I don't know that would be liability, but so it's a good news, bad news kind of thing. You can tow it to a different part. I think I'm here at the Houston Apartment Association offices, and I just was talking with Andy Tees, who is their government affairs guy, and he said, I can totally see where this is a good thing if you're trying to stripe a parking lot. And you've given the person the notice and given them the notice, and the car is there. You told them in the notice that if they don't move it, you're going to tow it. And so you move the car to the back side of the property where they're not striping or where they've already striped. That would be handy rather than having to go to a facility to get it. So we are still waiting on the commission to adopt some actually written, the Texas Commission of Licensing and Regulation, to adopt some, to write down some more specific rules. The second part of towing here that you need to be aware of, and this is also effective for new contracts signed after June 15th, it modifies your ability, and we do this all the time, right? When I was a property supervisor, did this all the time. An expired license plate or registration, I was going to tow that vehicle. So like before, the tow has to be in a contract. It is in our lease. It says it's going to be, if it's got an unexpired license plate, it's going to get towed. You have to be given 10 days written notice that the vehicle is going to be towed if it's not moved. The change is about this 10 days and the notice that you give. So we're protected in the lease thus far. I think in the next lease revision, Andy felt like there would be some revisions in the lease. But the new 10-day notice says that the vehicle does not display. It has to say in the notice. So you might want to adjust your towing notices now. It does not display an unexpired license plate or registration. The vehicle's going to be towed if it does not display an unexpired license plate, and they have to have a telephone number that's answered 24 hours of the day in order to locate the vehicle. And then that notice has to be delivered in one of the 3 ways here: in person, certified return receipt, or attached to the front windshield driver's side, or if the vehicle doesn't have a side window, to a conspicuous part of the window of the vehicle. Okay, so any questions on that? So really, two significant moves here on towing. You can now tow to another place on your property. If you're going to do that, I would sell that as a courtesy. In courtesy to you, Jody, we had to move the vehicle, but as one of our residents, we were able to have the tow truck just move it to a different part of the property and out of the way where we needed to, stripe the lot. So just remember the change to the notice language and how you deliver it. So that's already in effect. So if you're not doing it, please go ahead and get your notice language changed. Don't assume that your towing company is going to do that. Never assume anything from your towing company. Can we bill the resident for the courtesy tow if we relocate on the property? Absolutely. Don't make it usurious, make it reasonable, but absolutely. Because they would have to pay a scat of money to get it out of a lot. So courtesy, you know, and I like your phraseology there, is a courtesy tow. I love it. Be sure that's in the notice. I would, you know, if I were a resident and my car was getting towed, and I got that notice, I would want to know ahead of time. You know, if you don't tow it, so we're going to go back here. Let's go back here. So on the notice piece, let's make sure that we tell them it's going to be towed at your expense, and there'll be a courtesy expense if you're going to tow it on the lot. They actually might be really thrilled to find out that it's towed to the lot, and therefore the fee isn't as high. Credit cards. Now, this is kind of a jury's still out on this one, so this is just mostly a heads up for you. A little change, but just an important change. It just means that the agency that's now doing jurisdiction over credit cards is the Consumer Credit Commissioner to the Attorney General. It wasn't that way before. Used to be the Office of Consumer Credit Commission. So they're now going to investigate complaints. The ruling here is that we don't know whether this is going to be a good thing for us or a bad thing. There is a credit card surcharge. In other words, a limit to what you can charge for using a credit card. But there's a lot of that stuff being litigated right now. So just a heads up that they're looking closely at what is a fair credit card surcharge, what's a decent amount, and then know that it's not going to be the Office of Consumer Credit anymore as of next week. It's going to be the Consumer Credit Commissioner. So where Mr. Bookstaff said that we're just going to have to kind of stay tuned and wait to see what they decide to do about this. All right, one final and huge win for the TAA lease. And this is really important for us in our affordable properties where we have to have good cause to terminate someone's right of occupancy. So one final and big win. Okay, so there's a lot of printing here. It's called the Shields case. Okay, basically the Shields case. So if anybody's asking you questions about this, it's the Shields case. This just happened. So here's the scenario. Rent's due on the 1st, without prior demand. In other words, and this is on our TAA lease, we don't have to demand the rent. It's part of the lease. Failure to pay in this particular case with Boo Nathan Bradbury. You'll see why I'm in love with that name, Boo Nathan Bradbury. Failure to pay by the 10th in this particular lease, not in ours. Although it might, you know what, it might be in ours. It might be a failure to pay by the 10th is substantial default. So anyway, it was in this lease, substantial default. The landlord, Shields is the landlord. He continues to accept late payments from Boo. Boo is always late. The landlord doesn't complain, and he doesn't levy late fees. Okay? So he's collecting this late rent. The lease, at the same time, there was a clause in the lease that gave Bradbury the right to exercise an extension of his own lease with the only contingency that he had to fulfill all the terms and conditions of the lease. Okay? So everybody clear on the first 3 bullets? Rent was due on the 1st. Failure to pay by the 10th was substantial default, was considered, quote, substantial default. The landlord was customarily accepting late rent all the time, no complaint, no late fees, and the lease gave Bradbury the right to extend the lease as long as he was in compliance with the terms and conditions. Also, the last bullet had a non-waiver clause. Okay, and here's what a non-waiver clause says. that any waiver, waiver is like a permission, like a go-ahead. Any go-ahead must be in writing and signed by the person giving the go-ahead. Landlord's failure to enforce any provision of this lease or its acceptance of late rent shall not be a waiver, and shall not, stop is just a legal term for stop. It shall not stop the landlord from enforcing any other provision. So that waiver gave them a permission, gave the landlord a permission to continue with every other term of the lease, and that accepting of late rent did not waive or give the resident a go-ahead. All right, so one more little part of the story here. So the landlord decides that Bradbury had become a month-to-month holdover and that he, the landlord, was entitled to terminate the tenancy at any time with proper notice. Very much like us. You've got someone in a month-to-month situation, and you want to give them a notice to vacate. So the landlord files eviction for immediate possession. The landlord said that Bradbury could not exercise his right to lease extension because he hadn't fulfilled the terms and conditions of the lease due to the late rent. So remember on the previous slide, Bradbury had a right to extend the lease so long as he abided by the terms and conditions of the lease. So Bradbury goes back and says, hey, the landlord gave up that right when he continued to accept their late rent, and he didn't stop me. So how can he prevail in this? I had to get that picture of Boo Radley from To Kill a Mockingbird. So the court rules in favor of Shields because the parties had expressly agreed in the lease that acceptance of late payments was not a waiver of rights. So there was no waiver. There was no waiver. All right, that's a lot of legal language. So here's what comes for us. If the landlord had made an express, that means either a verbal or a written representation that late payments were always accepted or that late payments are always excused, there would have been a different outcome. So that means we should not make any oral or written representations that conflict with what the lease says, because what we do then is we shoot ourselves in the foot. So saying something like, oh, it's okay if the rent is late, okay, but let's not let it happen again. And remember, this can be verbal, ladies and gentlemen. So any kind of acquiescence or permission that you give to a resident who finally pays you rent, but it's late, if we say it's okay, thanks for the late rent, if it's a verbal statement, oops, I'm sorry, I got a chat question to follow up with. If the late rent is accepted, do not make any representation that, oh, well, thank you for bringing it in, that takes care of it. That would be perceived to be permission to be done with late rent. And you couldn't proceed with a late rent notice to vacate. So keep your mouth shut in terms of it being A-okay or, hey, okay, so we won't file eviction now. Because when you do, you don't need to do that anymore. And in fact, if you do it, you shoot yourself in the foot. All right, so I have a question here. If it's a verbal statement, will the court then accept the resident's version of the verbal agreement? Of course. So the eviction hold-off agreement is not a good tool to use. We should just accept the rent payment. Yeah. I don't even know what the eviction hold-off agreement is. That if they pay, you're going to hold off eviction. I would not use that. And I'm not a lawyer, so don't. I mean, if you've got folks that you work with on your properties, I would check with them. Here's what you should say: thank you for paying the rent. Every one of these late rent payment situations is handled individually. We'll have to see with the manager or the supervisor how that's going to mean for you as a continuing to live here. So I know this seems like a fine line, but basically what we do when we say, hey, thanks for bringing that, we'll pull the eviction. Don't make any promises like that, because it absolutely takes away your right to continue with the eviction. And you have a right to continue with the eviction, so long as you haven't made any representation that it cures their default, or that we will either not take action or we will remove action in return for payment of the rent. So the last bullet here from Howard says that if you are in an eviction case right now where the resident could argue that accepting the late rent waived your rights under the lease, show the JP this case. So you can now feel safer about accepting rent even after giving notice to vacate and filing an eviction if the payments made fail to bring the resident current. You can still take the rent. What's really important for us in our affordable properties is that we always had to have good cause for non-renews. So this strengthens your position where you've got folks that are habitually late paying residents. Before this, there was an argument that since you accepted the late rent, you couldn't use that as good cause. Now you can. Now you can. Houston, here I'm just asking about hurricane procedures. I don't have any. Actually, I just got an email last night from Mike that we might want to put something together because we've got a couple of Corpus Christi issues. I think there was some stuff in the shared drive under the safety. I think that Lynn Ben-Ami had written some stuff on hurricane prep, and I actually think Linda Coker's got something on hurricane prep as well. I don't have anything prepared to go over with them today, Sherry. If you've got something on hurricane prep and you want to share it, then we happy to have you share it or funnel it through your regional and let the regionals or the admins roll it out. I think Mike is probably doing that back at the office. I will check when I get off the webinar. All right, that's a lot of stuff. Any questions? I promised that I would make available this article so you can get all of Howard's suggestions in hand, so I will do that. I have one other thing that's not on the webinar, but you really need to know about. This is a court ruling from August 18th, so it just happened in Dallas District Court. They dismissed all claims against all defendants in a disparate impact case involving housing vouchers. So those of you on our conventional sites, it's a big win for us. Basically, that they dismissed a lawsuit that alleged that a property owner's refusal to accept housing vouchers was disparate impact and violated fair housing. The court did not file that. They said that was not the case. This is Lincoln Property Company for this win. So that's good news for us in the right to at least conduct our business the way we want to conduct our business. So there's a good little article about that on that just happening in the roof lines from the Apartment Association of Greater Dallas. So that's a good win for us if you're on a conventional property. All right, that's it for us. I appreciate you being on the call. I will reach out to Mike. And again, if you've got some hurricane preparation, I think somebody had just put in a website. Here's a website. Actually, it's basically FEMA could also give you something too. www.nhc, which is the National Hurricane Center, nhc.noaa.gov. Prepare ready. So it's a link for hurricane prep. The National Hurricane Center could also help. All right. All right, everybody, thanks for putting in your first name, last name, name of your property. Next month, I think I've got some really interesting stuff on leasing again. And so Alicia, you have to put your last name in, baby. Leasing is really going to be important now in September, our skills and our understanding and our outreach, because you're in the quieter time of the year. So we may have to go get some of those people and have them join us. All right. Thank you so very much. Have a great Friday, and talk to you next month.